Let's take a detailed look at how the Prime Minister's office reacted. They issued a statement this evening saying we welcome the fact that both the judges have completely vindicated the Prime Minister while appreciating the onerous duties of his office. That brings us to the big debate tonight. Is the Supreme Court judgment really a setback for the UPA? Isn't the government embarrassed about this? Do tell us what you think. Well, I spoke earlier today to Mr. Subramanian Swamy, the Minister of State in the Prime Minister's office, for more on this big story. Mr. Narayan Swamy, the BJP has said that today's Supreme Court ruling is a second indictment of the Prime Minister after the CVC fiasco. How do you react?
No, this is absolutely wrong on the part of BJP. BJP is doing politics and everything. As far as today the Supreme Court judgment is concerned, because you know pretty well that there is no settled law on the question of the sanction for prosecution earlier. And as far as the petition given by Subramanian Swamy is concerned, the PMO was considering that. And Subramanian Swamy went to court, and thereafter the court today, while giving its finding, it made an observation that 3 months should be the time, the maximum should be 4 months. And they said that for framing the guidelines relating to the sanction for prosecution, it can be framed by the Parliament. That therefore they left it to the Parliament to decide. Where is the question of indictment in that?
No, but
these are all the political ploy of BJP.
No, but Mr. Narayan Swamy, won't you concede that it is an embarrassment because the court's observations and guidelines today have come on Subramanian Swamy's plea in the A. Raja case, where there was a delay of 16 months in getting sanctioned for prosecution?
No, it is not an embarrassment to the government. How can we say it is an embarrassment? Because you know, as far as he gave a petition, when there are no materials available, the government has to consider all these things, because government cannot all of a sudden the sanction for prosecution. The Supreme Court also, because I have not gone through the judgment, they said unless until some kind of complaint is there, it cannot be considered, because Subramanian Swamy is filing a petition about everybody in this world, because that is his habit, that everybody knows in this country also. Because as far as our government is concerned, we have taken a proactive step. The Honorable Prime Minister, you know pretty well, the Lokpal bill that has been brought before the Parliament under Section 23. There is the sanction for prosecution is not required in the cases that are being instituted by the individuals or organizations against the public servants. The government has taken a proactive step. And in the other matters which are where we have to get sanction required for it, we will definitely we will go by the guideline that is to be framed by the Parliament, because these are all routine matters where the court certain time they give their observation, the government follows that observation. There is nothing, you cannot read in between the lines on that.
But you probably have to read in between the lines, Mr. Narayan Swamy, because the fact is that the court has given these observations and guidelines today on this particular plea in the A. Raja case. I mean, that is an indictment then, isn't it, of how the government handled that case?
No. How can you consider that? Because, you know, is there any rule which says within such and such time the sanction for prosecution has to be given? It is not like that unless until all the documents are available, because we are giving for CBI to sanction prosecution. It comes from the state governments and also from the central government officers. It comes to us. Then now we are, as soon as it comes within 2 days, we are clearing it. There is no question of any kind of delay unless until if it is in order, the government can wait for the documents to be given. Without that, the government cannot have and sanction for prosecution on anything without any material on record.
Now, Mr. Narayan Swamy, you're obviously happy that the judgment doesn't really hold the Prime Minister personally responsible for the delay. It says that his officials and advisors didn't really place all the facts before him. But it does have a very, it does have critical words on the PMO's role, and you can't escape that.
No, it is not like that, madam, I tell you, because whose duty is that to give the documents? The complainant who gives a petition, he has to give the documents. It is not the officers. The officers have to see the document that have come, whether it is required materials are there or not. and then they will submit before the Prime Minister for sanction for prosecution. As a minister, when I get the petition for sanction for prosecution from various ministries and the state government, I will see that our office will see whether it is in order, whether all the documents have been complied with. Subramanian Swamy filing a petition alone is not a ground for sanction for prosecution. There is no hard and fast rule. Unless until everything is in order, sanction for prosecution will not be given.
But sir, these are the words of the Supreme Court. These are not the words of Subramanian Swamy that we're talking about today.
Yeah, because we respect, madam, we respect the Supreme Court. We go by the Supreme Court's observation. Wherever there is some kind of correction has to be made, that we will do it. That does not mean that Subramanian Swamy, in his whole lifetime, he filed several petitions against several people. None of the petitions he succeeded. Everything was right from Ramakrishna Hegde. I have seen it.
All right. Mr. Narayan Swamy, in light of the scathing words on the PMO, in what the Supreme Court has said, let me ask you finally, will action be taken against those PMO officials who are responsible? Is someone going to be held accountable for why it took 16 months to sanction prosecution of A. Raja?
Madam, I told you already that, I saw only the observation that came in the media. I have not read the judgment. Let me go through the judgment before giving any reply to this, because I told you already, because I only saw from the electronic media about the Supreme Court observation. Supreme Court observation about the Parliament framing the guidelines, it is there, and they said that the 3 to 4 months the sanction for prosecution to be given. Madam, you have seen I have seen in my the career as a member of Parliament and also as a minister, I found that several rules, several observations given by the court, which have been accepted by the government, because it's one of the guidelines that has been given by the Supreme Court. There is nothing to read in between on that, nothing to say that is indictment on PMO, nothing to say that there is a fault on the part of the government, nothing of that sort in that.
All right, well, that's certainly the way you're looking at it, Mr. Narayan Swamy. Thank you very much for speaking to us tonight. Well, joining us on this big story tonight on Left, Right and Centre in our big debate, we're joined by the petitioner in this case, Mr. Subramanian Swamy. Also joining us from the Congress Party senior leader, Mr. Manishankar Iyer, who's also a Rajya Sabha MP. The BJP's national spokesperson, Nirmala Sitharaman, is with us. The former Attorney General of India, Mr. Soli Sarabji. Also joining us tonight is Mr. T.S.R. Subramaniam, the former Cabinet Secretary, Mr. Vinod Sharma, the political editor of the Hindustan Times. Let me first ask Mr. Manishankar Iyer, because I recorded this interview with Mr. Narayan Swamy before the PMO's official statement came out, Mr. Iyer. And when you read the PMO's official statement, they said that they are completely vindicated by what the court has said. Why is this statement so celebratory? Because while the Prime Minister may not have been personally held accountable for the delay, it's not like the PMO is escaping blame, and neither is the Law Ministry. So how can it be a complete vindication?
Well, I'd first like to say that I completely endorse everything that Mr. Narayan Swamy said to you. And I think the detail into which he went in responding to your very searching questions vindicates Mr. Narayan Swamy's role as the Minister of State in the Prime Minister's office and the one who's concerned with personnel questions. I cannot fault him on anything that he has said. As for the Prime Minister's office statement, I understand from you that there is a celebratory tone to it. I don't hear that actually in the few words that I've heard from you on that statement. It seems to me to be more a clarification. They have clarified what is self-evidently in the observations of the Supreme Court, that the Prime Minister is not to be held personally responsible. And for the rest, as Mr. Narayan Swamy said to you, it's after they have examined what exactly has been stated in detail that the question of whether or not any action against PMO officials or Law Ministry officials would arise. But as it has been stated before us in this program thus far, I think Narayan Swamy is on top of you, which rarely happens. So I wish to congratulate Narayan Swamy and commiserate with you.
No, but let me just read out to you from the judgment. You know, the court says, and yes, on the Prime Minister's point, it says he cannot be expected to personally look at the minute details of each and every case placed before him. But the court says, unfortunately, those who were expected to give him proper advice and place the full facts before him failed to do so. And that if he had been apprised of the true factual legal position. So, in other words, it's how can it be called a complete vindication? There is some accountability, no, on the part of the PMO here for the delay.
Please do not use words inappropriately in such a delicate matter. This is an observation of the court. It doesn't amount to a verdict. And what they have made is an observation which the minister concerned, I don't know about the statement from PMO, but the minister concerned has clarified to you in person that after they have examined the grounds on which this observation has been made, they will then see what is the appropriate action to be taken. So I'm afraid while there may be a great deal of media and even public excitement over what has been stated in the court, it is the duty of a responsible government to study carefully what has been stated. And it seems to me that the fundamental thrust of what has been said is that Parliament should examine the possibility of bringing what has hitherto been within exclusively the executive domain into the jurisdictional domain by passing a law which says that within so many months a decision in this regard should be taken. And the answer of the government is that if only the Lokpal bill as passed by the Lok Sabha had been passed by the Rajya Sabha, which inshallah will still happen, then for the cases coming before the Lokpal, there would be no question of waiting for anybody's sanction.
Okay, but Mr. Subramanian Swamy, these may
don't come before the Lokpal.
Sure, one sec.
And in the cases that don't come before the Lokpal, they will take into account the observations of the court in deciding what further executive
what has been
action
incredible
should be taken.
today is how the government hasn't been willing to accept that 16 months was a long time in deciding whether or not A. Raja should be prosecuted. Let me ask Mr. Subramanian Swamy. Yes, these are observations of the Supreme Court, but is there a moral indictment here more than anything else?
Moral indictment of whom? The PMO?
Yes.
Of course there is. There's not only a moral indictment, there is in future a possibility of us filing a case of malfeasance in public duty. Each of these people can be, under the tort law, prosecuted for having caused this loss, even if it's not a criminal prosecution, but it's a prosecution nevertheless. So there's no question about it that this Supreme Court observation has laid the foundation for that. The more important thing is, it's not only a 16-month period. What happened is that after 16 months, I went to the Supreme Court. If I had not gone to the Supreme Court, it would have been permanently lying in the Prime Minister's office. And I think Narayan Swamy made some very irrelevant remarks, saying that I have filed so many prosecutions and I succeeded nowhere. I did, in fact. Jayalalitha is still suffering for it in Bangalore. Ramkrishna Hegde had to resign his chief ministership, and then of course subsequently when the prosecution was going down, he died. So the question is didn't succeed. This kind of silly defense that the Congress party is putting up is reflective of the moral bankruptcy that they are suffering today.
Mr. Iyer, a quick response from you before I come to the BJP and Mr. Sarabji.
There's no need to respond. This man is a professional troublemaker. He can't get himself elected to Parliament, so he makes a nuisance of himself.
Well, you haven't managed to do it yourself, so don't talk about it.
All right. Let me come to Nirmala Sitharaman. Okay. Let's look at the rest of the judgment as far as the Prime Minister's role is concerned. Now, Ravi Shankar Prasad today said it was the second indictment of the Prime Minister himself after the CVC fiasco. Although when you look at the judge's observations, they say he can't be held personally responsible. He hadn't been appropriately informed of the case. Is it fair to then blame the Prime Minister himself?
If you're going to read every one of the lines, I think you then should also ask Mr. Narayan Swamy not to read between lines. It's blatantly apparent from every line that is there. No need to read between lines. The PMO has been held responsible for the delay in sanctioning the prosecution. Now, the PMO is his office, the Prime Minister's office. Personally, if the Prime Minister is not indicted, in so many words, the office that he runs has been held responsible for having delayed and with no justification, and however much the Congress party defends itself, I can understand Mr. Narayan Swamy and Mr. Manishankar Ayer, probably who doesn't speak for the Congress as he repeatedly says, are all in an unenviable position today. It is an indictment, be it through an observation of the Prime Minister's office. And if the person who's running the office is got to be given a grace mark, so be it. But the office which runs his entire, functioning, the CEO of the country, is being held responsible even through observations. Is the country there to ask questions or not? Are we hair-splitting on these sort of things? It was definitely 16 months, unjustifiable, and that has come out. And today, therefore, the question is, what about the others who are sitting in the cabinet? Is he going to delay the prosecution for them or even the questioning of these ministers? So therefore, it raises a very, very serious question. And the observations made by the Supreme Court saying, get back to the Parliament to amend the law is only to say restrict it in terms of time period, 3 months or 4 months. To say that we've already done something in the Lokpal, which is successfully not passed in the Rajya Sabha thanks to the way in which they operated, midnight drama, is not to claim any victory on that score. Pass it first, one. And second, to talk about Lokpal is a different thing, but also, till now what have you done about giving sanctions for others? You've been holding responsible people who are sitting there having taken equally the same kind of decision which Mr. Raja has taken, and you're not allowing any kind of investigation too. So there is a whole deal of cover-up which is going on. Today, one of it has got very clearly exposed.
Mr. Soli Sarabji, how do you look at today's Supreme Court ruling and the observations in particular? What implications does this have? And in your view, who's really been indicted here? Is it a vindication, a complete vindication of the Prime Minister, as the PMO says, or is there a moral indictment here of the PMO?
Well, let me say, I agree with the Minister that grant of sanction is a complex matter. It can't be given just at the drop of a hat. Many factors are to be considered, many pieces of evidence, but then it has to be done with a reasonable period. You can't delay it inordinately, and certainly 14 months or 16 months is inordinate delay. Because whole idea of sanction is to start the without a sanction prosecution does go ahead. So if you delay grant of sanction, you're delaying effective prosecution. So to that extent, the Supreme Court judgment is a wholesome judgment in the fact that they have laid down, I think, 3 months or 4 months, I don't know exactly, but definitely a reasonable period, and 4 months or 3 months is not something in which a sanction cannot be granted. It's not inadequate. But I don't quite see this as an indictment of the PMO and much less of the PM, though the political parties may have a different perception. I regard this as a strong criticism of the working of the PMO, and if anything, those persons responsible for this laxity, they should be proceeded against. But I don't think it would be correct, it would be too much to say, to read into it and say it's an indictment of the PM and PMO. At least that's not the way I view it.
Okay. Mr. Subramanian, what are the implications of this judgment? Is this going to, well, we do have the Lokpal bill which is stuck in the Rajya Sabha right now, but if this is implemented, will we see fast tracking of corruption cases?
You're talking about Lokpal?
Yes. And or even what the Supreme Court has
but
suggested.
I look at it from two separate perspectives. I think Mr. Swamy has done yeoman service in bringing this issue to light and focusing on delays. The issue of ministers going to jail, either in center or in state in such large numbers, those people in the limelight for the wrong reasons, is relatively new. But the fact is, using the single directive or 197 or different processes of government, for the last 60 years, the government, both in the center and the state, has filibustered continuously action against people working with themselves. Just as they have abused the CBI and the Enforcement Directorate, they have used this provision of the law. Some RTI applicant should go and ask Mr. Narayan Swamy, please give me a list of all those requests by CBI over the last 25 years. What is the average period it is spending here? So I think I see the larger good here. I'm not worried about indictment, etc., etc., that if the system gets cleaned up out of this, I think the government owes it to either a private litigant or to an agency like the CBI to say within a period. I would say if the CBI asks for registration and prosecution within 2 months, if a private person asks within 4 months, I would say this is a fairly reasonable period. But to say casually that it is the parliament to decide, as if it descended here from heavens. Here the court has said in a matter of law that the delay is improper. And I think, I see the good coming out of here is, I would have liked the minister to say, yes, within 3 months we will examine it as a policy issue, take it at the next parliament session and pass a law. 3 months, 2 months, 4 months is a matter of detail, but we will examine it and get it done.
But then for that you have to accept that there was a delay, don't you, Mr. Manishankar?
No. I'm not talking about this case. I am talking of whole sets of cases. If he goes to another 25 cases, same thing will happen. I know chief secretaries, ministers, chief ministers. Just get a list from Narayan Swamy. You'll be astounded to see 3 years, 5 years approvals are not given.
You get in the website of the CVC. I mean, I've got the complete list.
Go to the CVC.
But
3 years and 4 years.
So Mr. Iyer, is there at least an acceptance that this is a chronic problem as far as sanction of prosecution is concerned, at least on the principle?
But Nidhi, why don't you respond to the point very validly made by the former Cabinet Secretary, Mr. Subramanian? This has been with the government, irrespective of which party, including Nirmala's party, running the country.
Is measuring rod.
Now, it is evident that whether it's state governments or the central government, there have been numerous cases of delays beyond 3 months. And the point, the coda introduced by Mr. Narayan Swamy has not been commented on, which is that the process of consideration within a responsible government can only begin when the entire documentation is made available by the complainant if it's an individual complaint. Now, in these circumstances, I think what Narayan Swamy said is certainly to be taken extremely seriously, that on the one hand, with respect to matters that go before the Lokpal, the government have already accepted that there should be no governmental sanction. And he also added that with respect to governmental sanctions, once they have examined the entire statement of the court in full detail, they would wish to see what can be done about it. But please note that whether Mr. Subramanian wishes it or not, all the court has said is that Parliament should consider this, and we'll see whether Parliament has to consider this or whether an executive decision can be taken on its own. But I imagine that since all the parties represented in Parliament who have been either in office in the state government or the central government have in fact been quote unquote indicted, to use your favorite word, it is important that Parliament does consider this issue as suggested by the Supreme Court.
Okay, Mr. Vinod Sharma, where do you stand on this?
Well,
who's been indicted, criticized, whatever?
Well, I wonder whether anybody has been indicted. But quite surely, Dr. Swamy has a moral high ground today, regardless of who has lost the moral ground. But I view it more creatively. I think that, you know, in a coalition situation, if there is a law in place and which prescribes a time frame to grant prosecution sanction, then the whole issue of moral, political compulsions, which the Prime Minister has been talking about, that the delay was there on account of the man belonging to an alliance partner and where his writ doesn't run. In future, the alliance partners will not be able to put pressure on the Prime Minister or the main principal party around which the alliance is woven to stall sanctions.
Is this a complete vindication?
No, but no, I will tell you. You see, in politics, once there is judgment of this nature, you see, politics is a game of perceptions. Regardless of what the court has written and regardless of the nuances, government has a lot to explain. And, you know, in the kind of system that we run, the Prime Minister may not be accountable for an act of omission, but he is quite clearly responsible because it's his office. So on this, I wonder whether there can be any argument. But at the same time, I would tell you that this court judgment is not just for sanction. It is also for denial of sanction within that time frame, if there is lack of evidence. So it cuts either way. It is not that the chief executive's hands have been sort of tied by the court that once a private complainant comes or once the CBI comes, you have to say yes. No. The Prime Minister in his wisdom, or whoever is assigned via the law passed by Parliament, can take a decision based on evidence. And Dr. Swamy's plea has been that based on the evidence that he provided to the Prime Minister, he did not take a decision.
Yes.
That is his main complaint, you know. And I think for that there has been a redressal from the Supreme Court. And point number 2, even if the Parliament doesn't put in place the guidelines or an architecture, this shall remain a case law till the time they do it.
Well,
and the Lokpal is pending as well, yes.
See, first of all, in this channel, when I first raised it in the Supreme Court, this petition filed, we had Mr. Sibal and Mr. Salman Khurshid saying that the Prime Minister is not obliged to reply to an ordinary person like myself. He says, who's Swamy to expect that the Prime Minister would reply? Second, that now has been demolished in the judgment. The judgment said any citizen has a right to be, his petition to be answered. Second, they said, I should have gone to a police station and got an FIR registered. That has been shut down also. And now, in fact, the court has gone one step forward, which in fact, in my opinion, is the embedded revolutionary part of the order. They said for initiating an inquiry against any minister, you do not need sanction anymore. That's the constitutional right of a person to do so. And that is, in my opinion, the real thing which has liberated this whole concept of fighting for corruption. And it's something which the Congress party should really worry, because there are a large number of ministers who will be now investigated by petitions filed in the court.
Let me get Mr. Sarabji's view on that. Mr. Sarabji, do you agree that that really is the crux of what we can take away from this judgment? And given that you also have a Lokpal bill that's still pending in the Rajya Sabha, which also does away with sanction for prosecution altogether, how does this square off with that?
Now, Niti, let's understand, what is the rationale of sanction? The rationale of sanction is that officials doing their duty honestly are not exposed to vexatious, frivolous prosecution. That's the rationale. In fact, some jurisdictions have said that grant of sanction is actually the impediment to administration of justice, and they have said there should be no sanction at all. But we have kept the provision because to, as I said, save the officials from harassment. So in grant or not grant of sanction, there is not some great inquiry to be done about the guilt or innocence. Only the prima facie case has to be seen.
That's right.
And I don't see how that cannot be done within 3 months or 4 months. Because any delay in grant of sanction amounts to delay in prosecution, and that also means delay in administration of justice. So I think this is a very good wake-up call by the Supreme Court. Maybe you make a law, even if you don't make a law, the judgment of the Supreme Court is declaration of law and it's binding on all. And I think everyone should not really take stands. This is something which should be welcomed by all.
That's right.
And not treated as indictment or any other thing. Let's not get into those semantics. It is a forward move. It's a salutary judgment of the Supreme Court, in as much as it will not tolerate any further delay in grant of sanction or prosecution.
If they didn't think it was an indictment, and if it is not even a criticism of the PMO's functioning, I would then want to know, would they now, without any further delay, allow the inquiry on other ministers who are in the cabinet? It's not an indictment, it's not a criticism, follow the rule.
Or also Sonia Gandhi.
All right, Mr. Iyer, do you want to take that question?
You know, I wish Nirmala had this wisdom when George Fernandez was caught with his hands in the
No, today is the court. Today is the court, sir.
There are no end of BJP ministers who are involved in this kind of a thing. So it's not a question of the Congress party. It's a question of forms of governance in the country. And I think Soli Soraji has made it abundantly clear that within a stipulated period of time, perhaps the decision to grant or not grant sanction can be taken and given.
Why the semantics? Let us assume that they have not taken the criticism. I only simply plainly asked.
Why?
Don't talk about what has happened earlier. Today is the verdict or the observation which has come from the Supreme Court.
Why not?
Today is in the context of the Supreme Court. Today, what do you want to say?
Why?
In the context of Supreme Court, what do you want to say?
Yeah.
Why are you
Why
hiding?
not? It's certainly a question,
Why are you
sir.
hiding behind?
Oh, no, I'm not. We'll have a complete debate on
You're
it.
hiding all your party's sins, and they include the murder of thousands in Gujarat. All.
Wait a minute. Let him have his say. Oh, please,
No, but
go
we're
ahead.
not talking about the BJP's sins.
Maniji.
It's not a question of party.
No. Maniji, you can't constantly refer to Gujarat or any other when you asked a direct question.
Why not? Why
we shall
not?
certainly
Why
have a...
not?
We shall...
Your hands
Oh, please,
are
hold on.
dripping in blood. Therefore,
Hold
it
on
should
a
be.
minute.
Is he sober?
Hold on a minute. Mughal Sarai onwards, Begusarai onwards, many other till Assam, we can have a lot of discussion. Why not? We'll certainly have it. But today, my own and only question to you, sir, is I do not have the wisdom which you may have. But in your wisdom, in the light of this observation of the Supreme Court, would you like to tell me? Would you like to tell the viewers? It's not a criticism, but follow the law. I love questioning of ministers who are sitting there on whom not even one finger has been raised by any investigation agency only because you're not allowing them. Now let them have.
We'll find out about
We'll have a debate on Gujarat. We'll have a debate on everything that you want.
Let me
But
answer
don't
your
throw...
question.
Okay, let him answer.
Let me... Look, why don't you let me answer your question?
Go ahead. Please do.
Only after we follow what has been suggested by the Supreme Court, which is a discussion in Parliament, which will engage your party.
This is a complete cop-out.
As much as my party.
This is a complete cop-out. I can't accept this. Supreme Court has given a view, and a strong view, high common sense view. I think any responsible government should say we take it seriously.
That's it.
We will work it out and see how it can be implemented.
Not the
We
first
can't
time.
say we will think about it tomorrow.
This is not the first time. In the Vineet Narayan case, they said it 3 months. And the CBC also had brought it on 2008
No
circular.
one followed the Vineet Narayan judgment, yeah.
In Vineet Narayan said it, and then these two people took a hit behind. Why this judgment was necessary was because they hid behind it by saying this is only for bureaucrats. Then the court today made it clear it's not for bureaucrats, it applies to ministers too. It's just because of that.
And that is the reason why I asked this question.
No, I think that, the court has not given any directions to Parliament. It's just an advice from the court.
Right.
And
of course,
and Parliament can easily ignore it. If they don't follow that advice,
But
I don't think the court can act against Parliament.
Can't, but there's a certain moral...
But even in the absence of a parliamentary initiative, this is the law of the land. And I think Mr. Soli Soraabji has put it very well that, this systemic change we required in this country. We're going to have other governments as well. The other political parties which will come to power. They shall be as much accountable. They shall be as much under the thumb insofar as corruption is concerned.
If you don't pass this, amend the Section 19 of the Prevention Corruption Act, and you next time take 5 months, I will go to the court will automatically give me sanction.
Okay, let me
But Dr. Swamy, there is one problem.
De facto.
There's one problem. You see, this whole business of 4 months and then it would be presumed that the sanction has been granted.
Yeah.
This can lead to a lot of mischief.
Well,
this can lead to a lot of mischief.
Anything leads to
mischief. You just don't give sanction and the person gets hauled up.
That's where the efficiency of the department depends.
Okay, let me just take some comments.
So you decide.
I have a question for Mr. Swamy, and I also want Mr. Iyer to respond to it. Sir, communalism is as big a concern as corruption. Nobody felt embarrassed when the Ayodhya verdict got delayed for decades. Then why should the Prime Minister's office feel guilty for delay in permission for prosecution in the 2G scam?
Well, I'm not asking the Prime Minister to feel at all. I'm the one who's defending them in the Supreme Court. It's the Congress party which wants some other prince hanging around to occupy his seat that is pushing the Prime Minister out. It is I who is defending the Prime Minister. So don't tell me about the Prime Minister. As far as the Prime Minister's office is concerned, the documents that have been brought on record in the court after the court issued a notice to the Prime Minister for the first time in the history of India, those records clearly show that every letter I wrote to the Prime Minister was referred to by the Prime Minister to the officials. The officials said don't respond to it. It is that advice which the court has noticed.
Okay, 1 second.
So therefore, we have to take to task those officials. One of them who's got a promotion just now in later on in the litigation.
Let me ask Mr. Iyer this. Mr. Iyer, do you at least accept this point that those officials who were responsible for the 16-month delay, there should be action against them? I know Mr. Narayan Swamy said that they're going to study this judgment and see what it says. But in principle, should someone be held accountable in the PM's office for this delay?
If the examination that is made by the Prime Minister's office in detail of the observations of the Supreme Court lead to the conclusion to which you've jumped before reading the Supreme Court judgment, then of course action will have to be taken. But I do not know whether the examination which will be conducted by Mr. Narayan Swamy and his colleagues will lead to the conclusion to which you have jumped ab initio.
You don't think 16 months was an obscene delay, if I may use that word?
16 months, because I went to the Supreme Court.
I don't think you should be using words like obscene anyway.
Oh, right.
No, but 16 months, Mr. Iyer, no, seriously. 16 months to sanction prosecution in such a big scam like this?
I think it is not for me, because I'm not involved as a minister in this issue. It is for the ministers to answer your question, and I am not going to preempt their right to provide the clarifications which the current minister, Mr. Narayan Swamy, has promised to give you.
Okay, I think it's safe to hide behind Mr. Narayan Swamy today. Yes.
My name is Amit Dahiya Badshaw and I'm a poet. So I'll use the word obscene. I think it's a good word. I'm interested in the fundamentals and the processes that are behind these issues. And I believe that corruption is facilitated by the fact that the level of proactive citizenship is low. Now, when the Supreme Court passes a observation, a little while ago I was amused to hear Mr. Iyer say that it's just an observation. Well, this is the Supreme Court of India.
That's right.
And it's not just an observation. Even if you categorize it...
okay, Mr. Iyer.
I didn't say it was... I'm sorry, I did not say...
Yes, sir. I'm quoting
it was just an observation. I said it was an observation and not a verdict. Now,
we could play this back.
That's what I mean. I didn't mean that we should take it casually.
My point is
I think we should take it extremely seriously.
I'm talking about spin.
And Mr. Narayan Swamy has already said he's going to take it seriously.
May I complete my point?
I don't think Mr. Narayan Swamy has been so remembered in any program in such a long time. Last comment, yes.
Yeah, my question is with Mr. Iyer and the Nimla ma'am. I'm 30 years of age and I see what happened to Mr. Sukram and what's happening to Mr. Raja. Now the selection of Mr. Chitam is also being questioned as a parliament member. Why should I go ahead and cast my vote? Because my hard-earned money is being wasted like this. And my right as a citizen of India says that I should go and vote for the country and choose right people. Then why should I go ahead and vote for my country and use the democratic system?
Okay, so you are cynical about the whole system in the way everything's been conducted. Let the politicians wrap that up. Nirmala Sitharaman.
No, that's a very serious concern, no doubt. And all of us will have to prove that our commitment to cleansing the system, whether for big-ticket corruption or grassroots-level corruption, because I remember Mr. Narayan Swamy in the morning saying we are addressing the issue of grassroots-level corruption. I also want him to address big-ticket corruption. So the political conviction with which every party has to respond is there, and we'll all have to play in this fair game to clean the system and show that in the parliament we will work in such a way that the system will improve.
And you don't see that
institutions will...
You see, if he doesn't vote, he will lose even more money. So his best chance is to go and vote and see some good people manage to get in so that they can fight in parliament for you.
All right, I have to leave it at that. Thank you very much to the panel for coming in.